with Jake McKenzie of Intermark Legal. That is our topic for today. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is attorney Mac Pierre-Louis, lawyer, mediator, arbitrator, working throughout the states of Florida and Texas. And welcome back to LMI Podcast, where we talk about law and conflict resolution topics with professionals and everyday people. All right, so today I have a special guest, and that is Jake McKenzie of Intermark Legal. And Jake, how are you doing today?
I'm wonderful, Mac. Thanks for having me on the program.
Yes, sir. Hope you're staying warm where you are. And welcome to the show. Reached out to you guys. I'm not sure who reached out to who actually, but we wanted to connect just so we can have a conversation about what you guys do, what Intermark is, who you are, and why you guys created Intermark Legal, so that we can get onto this topic of juror psychology and what happens behind the scenes and how you guys how you guys help people put on their cases effectively. All right. So first off, who is Jake McKenzie, CEO of Intermark Legal?
Um, Mac, my background is actually in psychology. And then
Yes.
from psychology, I spent most of my career in marketing around a large advertising agency. And so I stumbled into the legal community almost by happenstance via some expert testimony. At the end of that case, the lawyers were asking me about the case, and I made some observations about how the jury was believing some things and not believing some things, not comprehending some things, and made some suggestions off shaping the case. Um, they ended up following the unsolicited advice. They won their case, got a maximum verdict, and invited me back to work on some other cases. And that's how we got into this. And what we realized is that the skills and techniques of marketing, of really understanding your audience and then shaping communications to change their beliefs and behavior, were the same things that trial lawyers did, and really needed to be doing. So applying psychology within juries um, helped lawyers achieve better outcomes. And that's how we got into this. And we've been doing this for the last few years, and it's really taken off and exploded.
Okay. So would you say that that's what inspired Intermark Legal to take, the hold? Was that your original experience dealing with that specific case?
Yeah, that's exactly right. And that attorney called and invited us to work on another larger case. And that case also went exceptionally well, great outcomes for them. Then he began talking about us to lots of other folks. And soon the phone was just ringing off the hook of other folks needing help. And so we decided, well, this is fun,
Yeah.
and we're really good at it. So we kind of hung out a shingle and adapted our marketing processes to this. And over the last few years, we built a team to support it, taken some of our staff psychologists and moved them over here. Same kind of research techniques and communications techniques, and just applied them to the courtroom.
Yes. So I saw on your site that you guys have a lot of PhDs and behavioral scientists who work with you. So why the hard approach toward psychological? Like, why is that so important?
It's a really good question. The short answer is because really understanding how people make decisions is a science-based deal. And the folks in the legal community have spent their entire careers learning to make unbelievable logical arguments because you're often in front of a jurist, you're applying cases of law. When you're talking to a jury of 12 everyday people, um, sometimes you have to step back and say the skills that made me a great lawyer in front of a judge or writing great briefs are different here. And really understanding what jurors walk into the room with and what information I need to present to them and not present to them to change their beliefs and behavior sometimes requires an outside perspective. And so this is where the art and science of really all the behavioral sciences, I use psychology colloquially, but I really mean sociology, psychology, behavioral economics, all about changing beliefs and behavior.
Got it. So can you share an example of how behavioral insights have shaped a winning case strategy from your experience?
Sure. One of my favorite examples was we were working on this multi-firm case, and there was one attorney that was very strong-willed, powerful personality, and he had spent 4 months developing and going through depositions for this one witness. Highly technical, uh, and we ran through some mock trials, exposed it to some mock juries, and what we found is that the juries did not like the witness, did not understand their testimony, and his testimony was not swaying anybody. And so, just helping them understand that, hey, even though we spent a lot of time pulling this um, witness, pulling the evidence associated with it, we needed to shelve the entire thing. And sometimes that's hard for attorneys to do. And by helping them to narrow the things that they presented significantly, they actually won the case and got a very substantial verdict. And so it's a simple example of sometimes when you're too close to the trees, you fail to see the forest.
Yeah.
That's one of the things that we can offer is to really help them understand how normal people will process information. And we often fall in love with the work that we have done. And sometimes it's hard to go, well, hey, even though I did a lot of work here, that's not going to persuade anybody.
Yeah. Well, do these cases tend to be in the same type of practice area, or like do you do criminal as well, or is it more pharmaceutical or civil, kind of cases, or what kind of cases do you guys touch?
It's been mostly civil cases, torts.
Yeah.
Have yet to work in criminal cases, although I imagine the same kind of rules apply.
Yeah.
Um, Really helping folks understand a jury pool and how they're going to process information and how to shape communications, the language associated with it, the things that you put in front of them, the things that you don't put in front of them, who on your team ought to be presenting information. There's a lot of dynamics that go into it, and it always starts with understanding your jury pool and who we want on that jury pool. So helping folks select a jury and then shape the information that we put in front of them.
Yeah, well, let's talk about that. So, that practice of called voir dire or voir dire in some parts of the country of selecting jurors from your communities to make up that pool who are going to make the decisions. So, how does Intermark Legal's processes, during the jury selection differ from the traditional methods that we're used to?
Great question. In some ways, they're going to be similar. Folks are bright about understanding that we need to really have an understanding of the jury pool. So we start with just simple directed research, first party research. We'll do online surveys against a jury pool. You do mock trials. And what you're trying to do is to filter out at broad strokes who are going to be good jurors and bad jurors for your level of argumentation, because people walk in with a certain belief about a topic. People are unique in that they don't have a lot of humility about what they know and don't know.
Mm,
And you're probably familiar with the Dunning-Kruger effect, which says that the less we know about a topic, the more we think that we're experts at it. And jurors are the same way. So
yeah,
really understanding who's going to have strong opinions, who's going to be open to your argumentation, and who is an intransigent, and then profile those folks. We may find out that retired people that used to run their own business are really terrible jurors for plaintiffs within a pharmaceutical case. And in which case, you need to know that before you get into the voir dire room.
yeah,
We usually find that it's not so homogeneous, but rather it's a psychological piece. Some people feel like they ought to control their environment. And so you want to be able to shape questions during that process that gets you to understand their frame of mind so that you can say, this person is going to be open to my argument, or this person's not going to be open to my argument. They're the ones I need to try to isolate. Or if we do have strikes, that gives us a candidate pool for who we need to try to eliminate from the jury pool. And then you need to understand, for most trials, it usually comes down to a handful of jurors. There's usually two or three folks that are going to determine where things are going to go. You need to know who those folks are, and you need to shape your communications towards those two or three people. If you're going to win 10 of the jury, why bother working on them? Let's focus on the two or three that are going to direct the case and make sure that we win those. So it's, to answer your question, Mac, and I realize I did it in a very long-winded
that's
fashion,
fine.
is research. Let's really understand who we're talking to and then develop questions to identify how they think.
Yeah, no, it's fascinating actually. There's so much that goes into this, making sure you have the right person in the pool that's going to make, the difference. And I wonder if you guys ever feel like you get it wrong. Might that happen?
Oh, sure. I mean, it is not an exact science. What we're doing is trying to increase the odds.
Yeah.
There was a case that we were involved with a few years ago where the lawyers felt pretty certain there was a demographic skew of folks that they wanted on the case. They ended up with what
Mhm.
they thought was a very favorable jury pool. And one of the folks that profiled, like they thought would be a great jury pool, one of them was not. They were an intransigent. And
Mm,
were highlighted the way they answered one of the questions was a flag to let them know that no, 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 just
mm.
because the color of this person's skin doesn't mean they all think that same way. You really got to understand how an individual processes information. And
Yeah.
so, really getting the psychology of jurors is much more important than the demographics of jurors. And that's a major takeaway for most lawyers.
Yeah. Interesting. So, what trends do you see in the legal field when it comes to leveraging psychology?
Um, I think you're seeing a lot more of the successful cases leverage firms like us to really understand how people process information and to take more time to think about how they're presenting that information. So, some of the bigger uh, trial outcomes on both sides, both for plaintiff and defense, are leveraging firms like us. And it's just the folks that have that level of humility to realize, hey, there are parts of law that we never got trained at. Some lawyers are naturally great at communications, naturally great at connecting with people. Um, but for most of the rest of us, spending some time with an outside group to really understand how to persuade folks can bear great benefits for them.
Yeah. So, what tell me about storytelling, because I can imagine in this whole space you have to be really really good at conveying. So now that you have the jurors that you want, how do you get them, to be convinced of your side of the case? So tell us, what role does storytelling and just visual communications play in winning these kind of cases?
Mike, that's such a great question. And you know this, but in a multi day trial, jurors are only going to remember a fraction of the information that's presented. They just don't have the attention span, they don't have the memory capacity. So we got to decide what it is we want them to remember. One of the easiest ways to get somebody to store something in long term memory is to tell them a story.
Yep.
If I were to start the story of, say, the Three Little Pigs, I imagine you could finish that story for me without any trouble, even though I don't know if you have kids, but you may not have heard or retold that story in
Yep.
decades. We'd
Right.
have no trouble with it. And it's because we're hardwired for narratives. Um, we also get our moral outcomes based off of narratives. Most of the stories we were told as children were told as stories. That's how we conveyed right
Mhm.
and wrong information,
Yeah.
how to make decisions
Aesop's
in ambiguous
fables, right?
circumstances.
Mhm.
Bingo.
Yeah.
And so tying your case to a narrative that we already have an understanding of a moral lesson within is a very powerful way of simplifying a case. This is a case of a wolf in sheep's clothing,
Mhm.
for something that involves fraud. And people go, oh, I know the case of the wolf in sheep's clothing, that
Yeah.
he tricked somebody in order to do harm. I get it. So if somebody told a lie, that is a narrative structure that automatically conveys a moral outcome. So it tells people how to behave in a certain set of information. And
Mm.
thus, stories help with both long term memory. Hey, will you remember the story that I'm telling?
Mm.
But stories also convey moral outcomes, how you ought to react to this story. Who is the bad guy? Who's the good guy? And what ought to happen as a result. Um, there's an old axiom in psychology and it applied to marketing, and it simply says, don't make me think. I try to remind lawyers of that all the time. The jurors don't really want to process information, weigh through things. They're looking for a simple outcome to complex information, and stories are a great way to provide that.
Yeah. So I was thinking, is it possible that one of the trends that comes from that could be, I guess, a backfiring of where if if the public generally start, getting onto this, and might this whole, the practice that you're doing, might it not create like a moral hazard in a way where people are starting to get smart enough to where they're like, hey, I just got a jury summons, and I don't want those people thinking that they know me trying to get into my head. I'm going to, push back against the system and not basically turn onto its head all the assumptions that the psychologists and the professionals might conclude. Is that possible? Do you think? Are you scared? And are you scared of that?
It's a great question, and particularly in the marketing world, I get asked that a lot, and the answer
Yeah.
is no. The psychological drivers, the heuristics, the decision heuristics that are baked into our thinking processes are pretty low brain stem. Like these happen without people's
Mm,
awareness or consideration. And you see it happen in the marketing space all the time. Like I'm sure you've heard of the concept of fear of missing out or social
mhm.
proof. Like
Yep.
you know what it is, and I
Yep.
assure you, it still has an effect on you, even though you know what's happening, and you may even be able to pick it out within the spots. But
Mm,
in a legal case, we're not really trying to do anything that is manipulative. We're
yeah.
just trying to take information and shape it so they actually process that information. Because that's typically the challenge is there's
Mm,
too much, jurors don't listen, or they didn't listen to the thing you really think is important or that really is important.
yeah.
And thus they get back to the jury room and they talk about something completely unrelated. So it's about organizing the information so that they can understand it in a way that's going to be most beneficial for you and your client.
Yeah. No, no, it's interesting. Years ago, I read a book. It was a book on marketing and how to sell something, and it was called Biology, but it was
Yeah,
starts with BUY, biology, right? And that it basically the thesis is basically that we're all hardwired, and it's kind of ingrained, and why we do certain things psychologically, and how then the marketer or the vendor can then it feels like manipulation, kind of like put certain sense into the air conditioner that would then
yep,
drive us towards making certain behaviors, or they'll say they put certain things on the menu of the restaurant on the top of the list because eh, because it makes people more likely to buy it. Uh, Lots of
that's right.
I guess to me, because I don't work in this world, eh, just does tricks in a way to get you to do something. You're not really doing that. You're more just trying to uncover what's already there amongst the pool of people so that your lawyers can then make the right decision and choosing the best possible people, right?
That's right. And somewhat related to that, a little bit of a back fun story.
Yeah, of
About 15 years ago, you probably had an economics class in college.
course.
Well, about a little over 15 years ago, they gave the Nobel Prize in economics to a psychologist by the name
Mm,
of Dr. Daniel Kahneman. It was the first time a non-economist had ever won it. It was very disruptive in the
mm,
economist community.
mm,
And he won it because he illustrated there's not one decision making system in the brain, there's two. There's the one that the economists always told us about. I can think through things very logically and rationally, and that does exist, but we really hate using it. That there's this other system that most people use to make the vast majority of their decisions, well north of 90% of all decisions you'll make over the course of the day, you'll use this. And you are unaware that it exists,
mhm,
and you're unaware of how it functions. He called it System One. It's a SPAS system, and jurors are using the same system to make decisions on cases. And the very brief, oversimplistic version of this is a law in psychology called the law of least effort. They want to look for simple answers to complex questions. So all this process, all that we do is really helping people understand who's walking into the room and how do I present information to them that they will understand and that will affect their thinking behavior. We can't change who people are. I can't really manipulate people. What we can do is elevate things that they will find interesting and relevant. We can
mm,
nudge them and really filter information that they'll find relevant. Like when you go into the grocery store, I can't get you to buy soup if you have no interest in buying soup.
mm.
But if you're going to buy soup, I can get you to consider this brand versus another brand, or maybe buy two cans because we put a discount on it rather than one can. We can nudge behavior. And that's really what you're doing here. If you've got a terrible case, I can't help you. If you've got a good case, you got a good
Yeah.
argument, I can help you highlight the things that will be most relevant and choose the language that will impact jurors.
Got it. Yeah. So if it's a close case, then your
That's right.
expertise really matters, right?
That's right.
Like I've told people all this all the time. I've gone through many trials, over the years, and I tell clients, look, it's about your facts. If you have good facts, then we can help you win this, even if you have a horrible lawyer. But if you have horrible facts, it doesn't matter if we're jumping on the table, pumping, our fists on the desk. Nothing we can do. And so a lot of it comes down to facts. But if it's a good case on both sides, and your team comes on, then I'm guessing that you're trying to give your side the edge when it comes to the human psychology approach.
Really well put. I mean, we can help increase the odds. Nothing in life is
Yeah.
a certainty, and certainly not what we do. We're trying to increase the odds of understanding what a jury thinks, of picking the right jurors, and of shaping communication so that we can get not only a good verdict but the right outcome holistically. And what's interesting to a lot of lawyers is same things apply to judges.
Hmm.
There was an interesting study a couple of months ago that showed that attractive lawyers get better outcomes. Now, when I say that, people go, oh, of course, that's not a shock. Jurors love attractive lawyers. What was really interesting is the same rules applied in front of jurists, so that judges gave better outcomes to attractive lawyers.
Yeah.
Now, that's shocking within this case, but it's just a reminder
Yeah.
that human decision making happens at an irrational level.
Yeah.
Uh, uh, Judges still are using system one. Thus, if you want to shape argumentation in front of a judge, you still got to think about what's going to be important to them. And it's not just a matter of having the right citations, it's about presenting the right narratives and the right structure so that they are looking for simple answers to their complex questions.
Exactly. Especially if you're a new lawyer in town and the judge doesn't know you and they don't know your pedigree, they don't know your, prior history.
That's
This
exactly
is
right.
kind of why I try to stay in my own personal, practice within the counties and the judges that I know. Otherwise, you
Ah, see, you're a psychologist as well. You want to
absolutely,
understand your
no,
audience.
absolutely,
I know that judge. I know how they like information. I know what
yeah,
arguments they resonate with, which ones they don't. And you get good at it. You become a psychologist for those
yeah,
judges, and it's a great example that the good lawyers all do that. You want to understand your audience and then shape your communications for that audience.
exactly. All right, Jake McKenzie, thank you so much for this conversation on jury psychology and what you do through Intermark Legal. All right, guys. Until next time, Jake, of course you're always welcome back. Love to keep this conversation going. But thank you so much for sharing this information with us today.
Mac, it's been a delight. Thank you so much for having us.
Yes, sir.